Hi everyone, this is John Gerardi with Right to Life of Central California, bringing you another in our 40 videos for 40 Days for Life series. 40 Days for Life is the international campaign of prayer and presence outside abortion clinics throughout the country and throughout the world. If you want to learn more about our campaign for 40 Days for Life here in Fresno, get in touch with us at Right to Life of Central California at 559-229-2229. Today on the show, I want to talk about a bad change that lies at the root of a lot of bad California state laws regarding abortion. And that was the decision in 1974 to add to the California Constitution a protection for a right to privacy. Now, privacy is, I guess, as a concept, a good thing. I like my privacy. You like your privacy. Now, the difficulty is, what kinds of private things do we have a constitutional right to, whether as Americans or as Californians? The U.S. Constitution never says anywhere that we have a right to privacy, but certain private kinds of things are protected. We have the Fourth Amendment under the U.S. Constitution, which protects us against unreasonable searches and seizures. If you want to come in my home and search around and you're the cops, you got to get a warrant for that first. We have various rights that protect certain kinds of private things under the First Amendment. It protects certain rights of freedom of speech and freedom of association, and some of that has to do with privacy. But a right to privacy writ large, it's nowhere to be found in the text of the Constitution. Now, Griswold versus Connecticut was a Supreme Court decision from the 1960s that said there is a fundamental constitutional right to privacy that involves intimate decisions between couples. This was in regards to a Connecticut law that was trying to ban the sale of certain kinds of contraceptives. That decision, Griswold versus Connecticut, wound up being the basis of Roe v. Wade. Roe v. Wade was premised on the idea that the 14th Amendment of the Constitution, which says that no state shall deprive anyone of life, liberty, or property without due process of law, that basically emanating from that, in order to have due process of law, privacy must be protected within society, and privacy extends to a woman's ability to choose abortion. Now, this never made sense because abortion is not really a private decision. Maybe it involves something that you don't want to tell every person that you meet, but as far as private from the perspective of should be secure from government oversight and regulation, it doesn't make much sense. There are all kinds of medical procedures that are subject to government oversight. In fact, public health is a classical thing that is supposed to be under the purview of state governments to regulate. Okay, why do you think Gavin Newsom has total plenary right to regulate everything regarding coronavirus? Because California state government has a lot of authority to regulate public health. So the notion that abortion, because it's a medical decision that involves a very personal choice, I guess, for someone, that therefore it's private and therefore protected under a constitutional right to privacy, is such bad reazoning. It involves going to an open to the public clinic or a doctor who's providing his services to the public. There are all kinds of aspects to abortion that really are not private, and heaven forbid you admit that the unborn child maybe is another human being worthy of some kind of legal recognition, then it's no longer private. You're infringing on the rights of another person, quite possibly. So the right to privacy was enshrined in California state law through an amendment to our state constitution in 1974. And all of the subsequent bad California state Supreme Court decisions that we've talked about in this series, how the California Supreme Court struck down laws requiring that parents give their consent first before their minor children can have an abortion. California laws trying to cut off California state funding for abortion through Medi-Cal. Those bad Supreme Court decisions have all flown from this notion under California law that the California Constitution protects a right to privacy. Again, it seems as though the only thing they think privacy really means is a right to have an abortion. For Right to Life of Central California, I'm John Gerardi.